people who are leaders.
Who's the greater the effect?
People are going into homes that are on the sale list. They're going into homes as babysitters. They're going into homes as children who are friends of your child, and they're going right to the medicine cabinet. Kids go there and get all of those pills and show up somewhere and have a huge party.
The use of drugs is still kind of glorified. You go back to the 60s when it was really glorified in music and things, and to this day it is, and it's almost taken as a matter of course. Like people will have a drink, people will exercise, and people can party, and people can take drugs. And I don't think they pay attention to the bad side effects.
We know there are more people with a substance abuse problem than all the people combined with lung, breast, and prostate cancer. We also know that we arrest 1.6 million people annually for substance abuse issues. It seems to me that criminal justice has a major role to play in substance abuse therapy. What's the best way to distribute the message? Well, that costs a lot of money, and we decided maybe the school building was a good place to do that. Traditionally, the local schoolhouse is a community center throughout all of our history.
When Angela approached me about this, I thought it was a great opportunity for the kids to see a jury take place, a trial take place in real life events.
Kids see the same teacher every year in a given discipline, and all that has its place, and it's very, very successful here. But once in a while you need to bring in another voice.
As a teacher, you're always looking for some creative way to get their attention, to keep their attention, and to let them walk away with something.
They gave the kids a sense of what can happen. And that's all you do in education. You present information to the kids to let them absorb it, because then in the end, they're going to make their own decisions about how to go forward.
And maybe the children will be interested in it, maybe they'll stay interested in it, and more importantly, they'll walk away with something of value.
Good afternoon, ladies and gentlemen of the jury. Welcome to the Court of Common Pleas here. You've been chosen today to be a jury in a case brought by the Commonwealth of Pennsylvania, wherein they're charging a young man named Billy Jones with 3 different crimes.
A lot of people like lawyer shows. I'm a lawyer, I'm a prosecutor, so let me take those experiences and create a trial-like atmosphere.
We were all given the opportunity to be on jury when our government teacher asked us to, if we would like to be on the jury.
So I thought it was a very good experience for them to see what real life jury would be and how situations would be handled in the courtroom.
There were kids, they wanted to be jurors. They wanted to be involved in a process. They were very eager.
Our responsibility was to listen to both the defendant and the prosecutor and hear their closings on the case and use that to make our decisions of whether or not it was guilty or not.
The trial was about the defendant, Billy Jones, who he had car troubles, and he was hitching a ride home with his friend, but on the way to their home, apparently, they were pulled over by the police for speeding, and when they stopped, a bag of heroin appeared from under the seat. The trial is about whether or not the bag of heroin is Billy Jones's or not.
It was on them to make the judgment, and they had to follow along, weigh the evidence, understand the law, and then make a decision that was truly just.
This is real life, a judge with real jury instructions. We can show them on one given day, one mistake can lead to a felony conviction. And at the same time, we're showing them through the medical evidence that on one exposure to some pill, you can be hopelessly addicted.
You always think a courtroom, you always think TV, unless you've ever been there. And I've never even been on jury duty, so I've never been in an actual courtroom setting to see what it was like.
And the mock trial has some really interesting components. It is very easy for an innocent person to be accused of conspiring to deliver or possessing a controlled substance.
Now, ladies and gentlemen of the jury, in this particular case, there was a stamp bag of heroin in front of the defendant, but we'll get to the real issue in the case, and that deals with intent.
It gave them some responsibility, and they were active participants. They weren't just watching a court show.
This trial experience was certainly way different than a normal classroom situation. A real judge, real attorneys.
We let the children know that 90% of the time you're making good choices, but on one given time, that's the one thing all parents fear. I'm a parent, I'm a grandparent. We always are afraid of that one mistake our kids are going to make.
And it was exciting to see real judges come in and have a case that any one of them could fall into.
So we're trying to tell them you don't have one mistake. If you're in the wrong car at the wrong time, and this was a real life trial situation, there is nothing theatrical about this.
All rise. The Court of Kennedy Catholic is now in session. The Honorable Christopher St. John presiding.
I was just kind of the court crier for the program that day. So introducing the judge, getting everybody to stand when they were supposed to stand and those kinds of things. It was a very interesting thing to do, and I had a lot of fun doing it.
One of our players, one of our contributors is Alexander Lindsay. He's a former U.S. attorney. He was on the short list for a federal judgeship once upon a time. He actually chose not to do it. Al teaches trial tactics. He's a brilliant defense attorney. He is going to show them something that lawyers pay to see, his closing argument. He's a lawyer's lawyer.
Now, ladies and gentlemen of the jury, let us assume for a minute that this individual knew that there was heroin there, that he possessed it. Let us assume for a moment that as the Commonwealth is trying to convince you this is a big-time drug dealer. What would be going through his head when they were followed by the police?
Al Lindsay tells you that the defendant's body language plays a huge role in that he was very calm during the trial. Most people can't remain calm under pressure. Some people deal with it differently, but it just depends on the person.
Well, as a juror, we were supposed to look at the facts in an unbiased view.
He talked about how how his body language said, you know, how could he be so calm in a situation like that if he was really a part of the heroin and it was his, and how he, you know, didn't plan on his car breaking down that day and everything else. So it really didn't make sense that the heroin was his.
And we don't have any mirror or television or internet access to what he was thinking. And so, ladies and gentlemen of the jury, what we must do in determining what his intent was is to examine the circumstances of what happened.
I tried to maintain a free mind and with the philosophy of innocent till proven guilty.
For sure that he didn't really react or try to hide the drugs under his seat. That was definitely a key statement for me.
The critical testimony is the testimony of the Commonwealth's chief witness, Lieutenant Robert Tragg. What did he say?
They said that the owner of the car was the driver's mom's boyfriend, and they stated that even the kid really didn't know his mom's boyfriend that well yet. He was kind of a new boyfriend.
We also have agreed, and we ask you to accept the fact that the quantity of heroin was of such a nature that it was packaged in such a way that the only conclusion that you can draw was it was possessed for the purpose of either selling it or delivering it to someone else.
Our prosecutor in this case was Miles Carson. He made one of those powerful prosecution arguments I've ever heard in my 28 years. I thought I've heard a lot, and I thought I heard it all. I learned something in my own mock trial.
In this situation, under these circumstances, this defendant had no choice. He was caught. He was caught with the drugs in the car. The driver of the car, if you note, was speeding.
And it was interesting also to see how like the judge presides over the court and what he does in the courtroom.
A reasonable doubt is a doubt that would restrain a reasonably careful and sensible person from acting upon a matter of importance in his or her own personal affairs.
Judge Christian St. John, I can still see, and I have goosebumps as I'm describing this, an entire gym full of children. And I used to be an assistant principal, and we all feared what the kids may do in a gym setting. And he looked up and said,
If you have an electronic device that is turned on at this point, you better turn it off now. If I hear one or if I see you doing any kind of electronic communicating with anyone, that device will be taken from you and you will be removed from this courtroom.
And when he said about cell phones, turn them off, and wish they listened to me like that. You know, it would be nice.
but he's a real judge, and that's what really happens in a courtroom.
Very early in his comments said, just remember, he was talking to the kids, you're not in the gym. Oh yeah, you are in the gym.
Ladies and gentlemen who are observing this trial, even though we are in a gymnasium, this is a court of law. The decorum that we observe in a court of law will be observed in this gymnasium today.
And it was very, very good, and the kids responded to him very, very well.
So he gave us an overview of what we would be dealing with and what the lawyers would be presenting and how our emotions should not get in the way of our verdict.
Well, watching court trials on TV and reading about them in the books, in the history books and whatnot, and then being an actual juror in a case, it was incredible.
The third element is that the defendant was aware of the item's presence and that the item, in fact, was the controlled substance charged. Was he aware? And ladies and gentlemen of the jury, on this particular element, we strongly contest that he was aware that the heroin was there.
To determine whether someone's innocent or guilty, you have to have belief beyond reasonable doubt.
When I first saw the defendant, Mr. Billy Jones, he was very calm when he talked and when he sat down. So you get that initial impression that he's innocent.
Now, ladies and gentlemen of the jury, what you should understand is the Commonwealth is not suggesting that this is some poor high school student who just was confused and was trying or experimenting with heroin. The Commonwealth is trying to convince you that this particular individual was what we call, back where I come from, a big-time pusher.
Each attorney was very persuasive. I found myself agreeing with, as soon as one finished, he brought up a lot of good points, but then the other attorney brought up other points and I was swayed that way.
This is not a case about a defendant who was in the wrong place at the wrong time.
It was really interesting and informative to see what actually happens in a courtroom and to see how a lawyer will take any situation and be able to do a good job of presenting the facts that are favorable to the ruling for their client.
The defendant is not a victim of circumstance.
Mr. Carson was trying to convince us that he was on his way to deliver the heroin.
He said that his car broke down and he didn't have any tow truck papers or anything saying that there was anything wrong with his car.
That's what he would have you believe by his own testimony, that he was just simply bumming a ride home that night or after school that day.
My response was, I looked at him, I was like, that's a really, really good point. But then Lindsay said that why would somebody have a bag of heroin and not try and cover up something illegal that's underneath the seat? So it was, they both were going at each other, but Lindsay made the better point.
But you took an oath as jurors. I have taken an oath as a prosecutor to consider cases based on the evidence, based on the facts.
And one thing that I thought really kind of swayed how I thought about it was when he was saying that if you were dealing with heroin and something that expensive, you wouldn't just leave it somewhere.
And what is he going to be doing if he knew that this heroin was under his seat? Is he not going to be trying to desperately get it under the seat?
You don't leave very, very expensive drugs underneath the seat if you're going to lend someone else your car, or if you're the driver or the passenger or whatever.
Why wouldn't he just put them in his book bag?
If you look at what happened at that particular instance, I'm sorry, folks. How can you believe that this kid knew that there was heroin there?
Thousands of dollars of heroin isn't just left somewhere that other people are going to use or going to see.
So you would most likely keep it close to you. So I think that kind of swayed me towards believing that he was guilty.
The critical testimony is the testimony of the Commonwealth's chief witness, Lieutenant Robert Tragg. What did he say?
Why was his car broken down? He never gave us a reason. If my car was broken down, I wouldn't leave it in a parking lot.
Yeah, it was kind of shoddy. There was a lot missing. I mean, they didn't test for fingerprints. They didn't, like, interview the mom's boyfriend.
Now, ladies and gentlemen of the jury, the Commonwealth is trying to prove to you that he was involved in a conspiracy, an agreement with other people to do this.
The car that they were riding in was not actually the driver's property. It was the driver's mother's boyfriend's property. And they were not sure whether or not it was their heroin or not.
Don't you get the feeling that what's occurred here is they don't know who possessed that? But they want you to find my client guilty beyond a reasonable doubt of having that possession. But they really don't have any idea.
Don't necessarily look at the defendant or the people he associates with. Like, don't try to stereotype him or take a view on things that don't necessarily reflect the facts that are given.
I urge you as you deliberate to think of the facts, to focus on the facts, focus on the law. Decide this case based on facts and law. I'm confident that you'll conclude that this young man is in fact guilty of possessing heroin with the intent to deliver.
You can't just walk in if you're a juror and predetermine how you're going to rule, because then you'll just be biased and you won't fully appreciate the facts and what's presented by each side.
Ladies and gentlemen of the jury, it is now my obligation to give you the final instructions concerning your duties in this matter.
We had to decide if the defendant was guilty or not.
I think we were split about half and half at first.
You are here as officers of the court, charged with the responsibility of participating in the administration of justice here in Mercer County. And your most important function is to determine the facts.
I guess you could say we argued. But you have to make a decision, so we made a decision.
That determination must be made solely from the evidence which was produced in this case while you were seated here as jurors in front of the court and the parties and the attorneys.
I never really thought with trials that it was dependent entirely on evidence, like that you couldn't put any of your opinions into it. Like, even if you thought that he was guilty, if there's not enough evidence, you can't convict him. I'd never thought of it like that.
After both presentations were made by both of the lawyers, we went back and I listed all the facts that we knew and all the evidence that was presented to the jury.
The verdict otherwise is in proper order. It's been signed. Would you give that back to the foreperson?
Our head juror, Pat, he took charge. You know, he wrote all the facts on the board, like guilty, not guilty.
We as the jury thought that we're very meticulous about the evidence being presented on the chalkboard because we didn't want the emotions to get the best of us.
And I tried to make it a visual representation of what was there.
We just brought up all the key factors of, you know, what each attorney had to say.
Maybe it didn't make sense that another person had left the drugs in the car, but there also wasn't any evidence that directly said that it was the defendant's drugs.
Like, because he didn't reach down to slide the heroin back underneath his seat, that was also a big factor.
There were several of us that they believed he was guilty, and several believed he was innocent, but we were so torn that we didn't have enough evidence to prove whether or not he was guilty or innocent.
Now what I need you to do is read the verdict aloud so that everybody in here can hear that. Start with the paragraph that says, "And now on this."
There was a group that was really thought he was guilty and really thought he was innocent. It was pretty divided. But eventually, after we just wrote out all the evidence and thought it over, we couldn't find enough to say it was definitely without a doubt that he was guilty.
And now, this 12th day of April, 2013, we, the jurors,
and paneled in the above-captioned manner, render the following verdict. On the charge of possession of heroin with the intent to deliver, we find the defendant, Billy Jones, not guilty.
Let's maintain order here in the court. This isn't a gymnasium.
I mean, we talked about what should have been there. So, like, we mentioned the lack of evidence. And, like, that's kind of how we decided not guilty.
Even though a bunch of us were, quote, team boyfriend, where we thought it was the driver's mom's boyfriend's heroin, but we couldn't let that get the best of us because we had to look at the facts.
But the biggest thing that jumped out at me was some of the lack of evidence. And the biggest one of that is that there was nothing presented, like forensic evidence, that fingerprints were taken of the bag. Because that could tell you who were the people that were touching it, and that would really fill in some gaps there.
There was reasonable doubt, so in the end, we made the deliberation that he wasn't guilty.
How do you find on the third charge?
On the charge of simple possession of heroin, we find the defendant, Billy Jones, not guilty.
Would you hand the verdict slip then to the tip staff, please?
And I think once we saw the facts written down, we decided not guilty.
We looked at the evidence and the facts, and we decided that he was not guilty because there was not enough evidence there.
The verdict has been substantiated by the poll. I'll direct that the verdict be recorded. Has the jury reached a verdict?
Yes, we have.
Would you please give the verdict slip to the tip staff? The verdict is in proper form. Would you return it to the foreperson? Gerald, if you would get closer to the microphone and read the verdict, please, starting with the first line at the top.
And
would,
now...
Would the defendant please rise?
Right.
You can start now.
And now, on this 25th day of April, 2014, we, the jurors impaneled in this case, render the following verdicts. On the charge of simple possession of a controlled substance, we find the defendant guilty.
Settle down, ladies and gentlemen.
On the charge of possession of a controlled substance with the intent to deliver it, we find the defendant guilty. On the charge of criminal conspiracy to possess a controlled substance with the intent to deliver it, we find the defendant guilty.
Go ahead.
We find that the government has proven beyond a reasonable doubt that the weight of the heroin was in the following category, which is 50 grams or more.
Thank you. Would you give the verdict slip, please, to the tip staff? You may be seated. Ladies and gentlemen of the jury, that concludes your jury service on this case. So with the thanks to the court and the parties in this matter, you are excused from further jury duty.
Like, you don't even have to be doing something wrong. You could just be a victim of circumstance, and your life could change in an instant. So you better be very careful what you're doing and make some good decisions.
I wanted the students to see that this could happen to anybody.
Think about what you see that is influencing your judgment. Ask if it makes any sense, and get as much information as you can, and listen to people who care about you, who are presenting information to you that show you the dangers.
And they need to understand how the law works and how serious these, even something that they may view as minor, can affect the rest of their lives.
We brought this thing to as real a potential as entirely possible. I challenge anyone to show us anywhere where it wasn't real life.
I always say if I can affect one person, I've done something right. So if one person out of 300 took something away from it, we've done our job.
And that's all we try to do. Give them the information they need to make good, quality decisions.